All right, hi, welcome back. Attorney Steve Vondran here. We are bringing you another great video. This one dealing with the law of negligence. Now, negligence is obviously a gigantic area of the law. I haven't talked about it much, so I thought this would be a great opportunity for my law student peeps out there, my paralegal peeps, and my general fans that just want to know more about law. Now, negligence, the best way to think of it is about like a car crash, okay? When somebody crashes at an intersection, probably somebody was negligent. Maybe not, but probably. So, but there's basically, this is a general legal information under California law, and I'm going to talk about the 4 factors of negligence under California law, and in particular, can you sue for negligent transmission of the COVID-19 virus, aka China virus, aka Wuhan virus, aka coronavirus, all kinds of names that you hear out there. But let's take a quick look, okay? General legal information only, as I mentioned. I have more information at COVID Counsel. Now, you should go check out COVID Counsel. It's really interesting. I'm tracking all the new issues that we have never seen before, that this virus has brought on, that we're all dealing with, this pandemic. And it's pretty interesting if you want to go and you got some free time and you want to look at some of the new issues, many constitutional issues, which are arising for the first time. So check that out, covidcounsel.com. All right, let's move on. Potential types of transmission claims. We are seeing lawsuits filed against cruise ships, restaurants, some other places you may see lawsuits arising where people are gathering. Amusement parks, I see some of the parks are open, some of them are shut. There doesn't seem to be a lot of consistency in this. Sports venues are now, for the most part, shut, but there's talk of those opening up. Any places where people gather, any places where you're going to find masks, any places where you should have cleaning and surface cleaning, sanitizing. They should be putting up new sanitizers everywhere you go. That should be a huge business, by the way, if somebody wanted to get into that. Hand sanitizers, mobile hand sanitizers. You heard it here first. Shopping centers, Costco and Walmart, places like that. The big grocery chains, we know they're still open. You can go in and this, that, and the other. There is risk for the people that work there and also the customers and any other intentional or negligent spreading of a disease or virus. All right, so the elements of negligence, and negligence should be distinguished between negligence and intentional torts. Intentional torts are when you intend to do something. You walk up and you punch somebody, or you go and you throw a rock at them, okay? Things like that are intentional. You intended the act, okay? You don't always intend the outcome, but you intend the act, okay? That's intentional. Negligence is a bit different, okay? To prevail in an action for negligence, the plaintiff must demonstrate that the defendant owed a duty, this is key, owed a duty to the plaintiff, that the defendant breached the duty, and that the breach proximately caused the plaintiff's injuries or damages. Okay, there's a case for you, California case law from California, Witkin's Summary of Law, and the 11th, Section 11th on torts. Okay, now, every now and then I get to brag. So I am jured the torts, so in class in law school. So I know a little something about torts. I actually happen to be very good at it for some odd reason. But let's break it down for you. The elements of negligence, very, very simple. Duty, breach, causation, damages. So now if you're on your bar exam and you see somebody hit each other in a car, or somebody falls into a pit on a construction site, and you wonder, was there adequate warning labels, this, that, and the other, you say the issue here is whether or not the defendant can be held liable for negligence. Negligence, here's the black letter law right here, requires a showing of duty, breach, causation, and damages. Now let's dig into those just a little bit further. Duty. Okay, the first and most important thing in regards to duty is you have to show that the defendant had a duty or owed a duty of due care. Okay, now different ways a duty can arise. A statute can create a duty. A statute can say if you're working on the side of the road and digging, you must put warning signs up every 25 feet, this, that, and the other. So a statute can create a duty. Here's the second one I like this. Voluntary undertaking can create a duty. This is the law school one where somebody is screaming for help in the water, they're drowning. You don't have a duty to help that person. I know it sounds crazy, but you can watch them drown. Now, if you voluntarily undertake, if you swim out there and you say, I got this, everybody back off, and somehow you help the person to drown, a voluntary undertaking can create a duty. Okay. Other areas, foreseeable risk can create a duty. If you're working on top of a building and you're working with cement, big bags, obviously there's a foreseeable risk. If the bag falls off the top of the roof, you could hit somebody below. So foreseeable risk can create a duty. These are some of the basic things, okay? There are many other issues in law school. When you go to law school, you study duty for like 2-3 weeks, okay? Also, speaking of statutes and rules, California Civil Code Section 1714A provides everyone is responsible not only for the result of his or her willful acts, because that's intentional, right, but also for an injury occasioned to another by his or her, here's your negligence terms, want of ordinary care or skill in the management of his or her person or property. So this could be running your business. This could be how you conduct your person out in public. Many other states have similar laws. All persons are required to use ordinary care to prevent others from being injured as a result of their conduct. That's an old case you study in law school, Rowland versus Christian. So the duty, the first step is to say, is there a duty? What creates a duty? Here's a California Civil Code section that creates a duty, okay? In case law. Duty to exercise ordinary care. What is that duty? All persons are required to use ordinary care to prevent others from being injured as a result of their conduct. What is that? Ordinary care is that degree of care which people ordinarily prudent behavior can be reasonably expected to exercise under the circumstances of a given case. In other words, the care required must be in proportion to the danger to be avoided and the consequences that might be reasonably anticipated. Okay, so you have a duty of care, and then also you want to talk on your bar exams. Well, what exactly is that duty? What would the reasonable person have done? And books have been written about reasonable person. What is a reasonable person anymore? All right, so that's stuff that goes to trial, or you figure out, you argue. Breach. The second element, if you show there's a duty of reasonable care, you must show a breach. Now, when I say you must show, that means plaintiff must show. The plaintiff has the burden of proof here. Burden of proof being preponderance of the evidence as to each element here, okay? Breach of the duty to exercise reasonable ordinary care, not acting as the reasonable person. And this is what we refer to as objective standard. We don't care what you were thinking. We say, what would a reasonable person does, looking at this objectively. Quote, after establishing the existence of a duty of care owed by the defendant, a plaintiff, to support a claim of negligence, must show that the defendant breached that duty, the reasonable person standard. There's a little legal citation for you. Now, some ideas in the world of COVID and transmission of viruses and things like that, there's all kinds of things. We know there's mask requirements, but the standards, to me, appear to be less than scientific. For example, you see things that oftentimes wearing a bandana is okay, or here's how you make your home mask. Now, we know that diseases, viruses have micron sizes, like the COVID virus has a micron size, and we know a mask it varies. It can vary on the size. It's like a chain link fence, okay? So the question is, if you use a lousy mask and you're sick and you go out into public, are you being negligent if you expose somebody else with your less than impressive, less than scientifically protected mask? Things like that. Knowingly affecting others. There was a video online I saw, of a lady who was in a computer shop, and she was running around with some kind of cloth, and she was rubbing all the computers down, and some lady called her out and said, "Ma'am, what are you doing?" And she looked very sinister. I don't know what she was doing, but you can find that video out there. But that could be intentionally inflicting others with the COVID disease or the COVID virus. Lack of sanitary measures. Here's one that I like too, okay? So now you have all these businesses telling you all these things. You need to do this, you need to stand here, distance over here, wear your mask here. If you're under 6 in one county, well, then you don't have to wear a mask. If you're under 12 in some counties, you don't have to wear a mask. The ages are differing. So it's hard to find, but, so businesses are asking a lot of people. But my question is what are the people asking in return? If I come into your store, can you guarantee me you're wiping down the checking counter, the checkout stand? Are you wiping that down after every use? People are touching it. People are putting their fingers on things. They're not wearing gloves. Gloves are usually not required anywhere. These kinds of things. Could this amount to negligence? Could this amount to a breach of the duty? We do know that COVID is on surfaces. How long it lives on a surface, that seems to be a question of dispute. But are they wiping down the surfaces? Does the store have hand sanitizers readily available? I just went into a restaurant the other day, and right at the beginning, they would be spraying you with hand sanitizer. So, they are taking measures. But how about that business that's lacking any proof of extra sanitary measures right now? Defective masks, like I said, the bandana. And how about intentional violation of social distancing or negligent social distancing? You're roaming around, bumping into people, and just pretending like it's no big deal, okay? These could be considered breaches. These are just a few ideas. There could be a lot of other ideas. The facts always matter. Every case is different. You got to drill down, and look at your facts, okay? So there's your duty. There's your breach. Moving on. Now, sometimes you may not be able to say, well, how did they breach it? I can't put my finger on it. We have this doctrine. That's my favorite. This is my favorite in law school. I was hoping so bad that this was on the test because I was so ready for it. I just love the Latin term res ipsa loquitur, to help establish the breach, okay? Res ipsa loquitur basically means the thing speaks for itself. These kinds of things don't normally happen if somebody wasn't negligent. And in those types of instances, as you can see in my third bullet point, negligence is presumed. Negligence is presumed, and it shifts the burden of producing evidence to the defendant. Okay, so again, doctrine can allow a plaintiff to avoid summary judgment or a directed verdict. I'm going to let you read these if you want to read it. It's going to give you the standards here. Whoops, what happened? Certain kinds of accidents are so likely to have been caused by the defendant's negligence that one may fairly say the thing speaks for itself. The Latin equivalent of the phrase res ipsa loquitur was first applied. Here's that barrel of flour case that I was kind of alluding to. Rolled out of the window of the defendant's warehouse onto the plaintiff's head. Byrne versus Bodle, 1863. That's a classic law school case here. How did the flour hit the person? Must have been negligent. That doesn't normally happen unless somebody was being negligent or not caring, okay? So the plaintiff got to establish the breach, and like I said, there was no proof. Burden shifts to the defendant to say, hey, we took all the precautions in the world. So I'm going to let you look at that. Here's your law school clip. If you have, you're looking for the 3 factors. I'm going to let you read it. I'm not going to bore the rest of the people, but there's 3 factors, and you want to talk about these on your law school exams, your bar exam. Boom. But I'm going to move on here, okay? Causation. So duty, breach, causation. Okay, so you must prove that the breach of the duty of care caused, there's your word, caused the plaintiff's damages. Certain intervening or superseding causes. This could be where somebody gets hurt and then the ambulance comes and then the ambulance is negligent and you say, well, wait a second. Oh, it sounds like it's the ambulance is at fault, not me. I may have hit him with my car, but it's the ambulance that made it bad. Well, California has adopted the substantial factor test. Okay, so usually what I remember from law school is if the intervening superseding cause is foreseeable, then the defendant will probably be held liable for the damages. If it's completely unforeseeable, then that could be a different story. But this is where you have experts, the burden of proof. Was it a substantial factor in causing the damages? Okay, so you can pause and read that if you want. So we have duty, breach, causation, and of course the last one's damage. You must have some kind of damages, serious injuries due to intentional or negligent transmission of virus. Maybe somebody puts you in the hospital. You have medical bills. Maybe you haven't been out in public in 3 months, and you go out to a sporting event. Say they open up the sporting events. You go out, and all of a sudden you get COVID day one. You go out there, and now you have COVID. Something like that. You may need experts to prove it and say, how could this be? You may need to look at the records. Are they cleaning? Are they sanitizing? Are they washing the seats? All kinds of things could be popping up. Wrongful death, medical bills, lost wage, all those kinds of things, okay? So those are the 4 factors: duty, breach, causation, damages. If you go to law school, you commit those to memory. You'll remember it 25 years later. Duty, breach, causation, damages. Duty, breach, causation, damages. Duty, breach, causation, damages, okay? And this applies in other disease transmission cases. We do have some legal precedent in other areas. For example, herpes. Doe versus Roe. That's an exciting name, title of a case. Liability for transmission of herpes, where it was undisputed that the defendant had actual knowledge he was infected with herpes and had several prior outbreaks, but he believed he could not transmit it to the plaintiff as long as he was symptom-free. In affirming judgment for the plaintiff, the court emphasized the defendant admittedly had actual knowledge that herpes was a sexually transmissible. Okay? It's like COVID. We know it's transmissible. We know that. Having discovered that he had a venereal disease, he did nothing. Okay? So there's case law for you. So it's the same thing, transmitting, harming others. In a way, you could also look at it as an intentional battery. A battery is a harmful or intensive bodily contact with another. And if you know you have something, there's cases where you know you have herpes and you go sleep with somebody, or you have, other, diseases. It's kind of like a battery if you know you're doing it, and it's negligent. It can be negligent if you're acting like it just, didn't even give it 2 thoughts. HIV, here was another case. Husband was sued by his wife. How about that one? For infecting her with HIV. John B. versus Superior Court, 2006 case. John B. Court found liability for negligent transmission of HIV extends to situations where the actor, under the totality of the circumstances, had reason to know of the infection. So if you get tested, you say, it looks like it came out positive for COVID. And I see people doing this. They'll get tested positive, and then they'll go out into public, and they'll say, well, I'm positive, but I'll wear a bandana. Wear a bandana. And I say, okay, seems like maybe somebody's being put at risk. By the way, I'm not a medical doctor. This is not medical advice. Check your local rules, your local governor orders, your executive orders, your local rules. But I just wanted you to show you these things. So I think there is some liability that is going to be potential out there. We are going to see cases. We're already seeing cases. And coming attractions, hopefully not. But people are talking about the vaccine. There's going to apparently be some kind of vaccine. They're talking about therapeutics. They're talking about existing drugs. But most people don't know there is a United States Court of Federal Claims in Washington, D.C. that handles what we call vaccine injury. Did anybody know about that? Be honest. Did you know? If you didn't, you better bookmark my page. This is where you come to learn more. Be smarter than your friends, as we like to say. U.S. Court of Federal Claims, Washington, D.C. And there was a lot of autism claims out there, by the way, but where the government is forcing vaccines and injury is caused, there is a whole set of rules and a court and a whole thing. You can be compensated. Is this coming next? We'll have to keep an eye on it. There's talk about a vaccine later this year or next year. Maybe it is, maybe it isn't, who knows, but I put that on my PowerPoint just so you could put it on your radar. All right, there it is. You got any questions? Like I said, every case is different. We don't take every case. You got to look at the facts. You got to look at the law in your jurisdiction. We're licensed in California and Arizona. Again, this is not legal advice, general information only. We've been in civil litigation since 2004. It's about 15, going on 16 years here, over 200 federal and state court lawsuits, tenacious representation. We fight for your rights ethically. We're not the crazy pit dogs that like to tear people's legs off. We like to call it tenacious, honest, ethical representation. Okay, if you need some help, there's our number. Thank you for watching this video. Feel free to subscribe to our channel. If you have any comments, put them down below. It's okay. Keep it nice, keep it friendly. I don't run a bully page, so just keep it nice, keep it friendly. We try to learn, we try to share thoughts and comments, and we try to learn here. And don't be afraid to hit that like button. Okay, Attorney Steve out. You can find more information about our firm at attorneysteve.com. That's attorneysteve.com. Thanks for watching. Have a great week. We'll be back. We've got other great videos getting ready for you here, okay? That is negligent transmission of COVID, coronavirus, so forth and so on, okay? Take care now.